Good afternoon and welcome to the Cordell Cordell 10 Stupidest Mistakes Men Make When Facing Divorce for our lunch or afternoon webinar. As many of you may know, this is a similar webinar or seminar that we give in the evenings, but a much more condensed version. We want to bring these to you in the course of the next hour. We're going to go through quite a few of our topics in very light detail to go through each of those, but enough to give you some information as you may be facing divorce, preparing for it, or in the middle of a divorce. We'll talk a little bit about Cordell Cordell real quickly if you're not familiar with us. We have offices around the country, including Nevada, in Henderson. If you need to make an appointment, obviously, to consult with an attorney, we'll give you some of that information at the conclusion of this seminar. I'm Scott Trout. I'm the CEO and managing partner of Cordell Cordell. Keep in mind that today I am licensed in Missouri, Illinois, and Georgia. I'm not licensed in Nevada, so I'm not going to be giving you any legal advice today, nor would it be appropriate for me to do so. That's really better spent on a one-on-one conversation, which we always talk about in our evening seminars, where we're going to encourage you. One of the reasons to go through this seminar and get some of the information is to really create an opportunity for you to create a list of questions and some topics for you to go have a conversation with your attorney. So again, I'm not going to give you advice. I am simply going to go through some of these mistakes with my 27 plus years of experience doing family law, and we'll go through some of those together. So again, at the end of the slide and then at the end of the presentation, there'll be an opportunity for you to submit some questions via the online chat. If we have some time, I'll try to get to some of those questions, but keep in mind there'll be a high-level response. I can't give you legal advice, and I wouldn't want to do that either. So let's get right into it because we have a lot of material to cover. The first mistake that we often address in our evening seminars is typically the first question I get when clients come in for a consult. And they do that around the country, whether it's me or someone else with Cordell Cordell. And that is, should I move out of the house? It's a key question that guys have, and it's important because one of the things that you need to think about is that every decision that you make has a consequence in divorce, even post-divorce, and modifications, and paternities, and contempts. So everything you do has a consequence. So that's one of the reasons we start with this one, is for you to talk about with your attorney whether or not I should move out. But generally speaking, when guys come in, I usually say don't move out. Now keep in mind if you have issues of domestic violence or you fear for your safety, whatever that may be, those of course would dictate a different answer for you. But let's talk about moving out and our general recommendation to not move out when it comes to whether you have kids or no kids, because there are consequences with both. So let's talk about kids. If I choose to move out, let's make the assumption that you've come to me and said, look, I moved out. Have I moved out? Well, either way, you're leaving the kids behind. And by that, I mean not necessarily an abandonment or desertion from a technical legal sense. But what I say is that when you do move out, you lose a little bit of control. And that is, I'll give you a scenario. You move out of the house. You've gone to your own place. You want to have some time with your kids. You call your wife and say, look, I'm going to come by. It's Friday. I'm going to pick them up. She says, fine. You show up and she says, you know what? Today is not a good day. It's not a good time. And so she slams the door in your face. By leaving the kids behind, you're losing the control in which you get to see them as often as you want. If you stayed in the house, you get to see them all the time. But moving out, she's now in control. You come back the next day, nope, not a good day. Or she doesn't answer the door. You don't have a court order. You don't necessarily have enforceable rights. You could call the police, but they're not going to do much for you. They're just going to say, you know what, we're going to let the judge deal with that. So you're assuring yourself of minimum custody before you get to court. Imagine this. If you go this long period of time, you've moved out, and she's rejecting and refusing to give you what you really feel you're entitled to or any quality time. 6 months later, you finally go to court and you get a trial in your divorce. The testimony would be, how often did you have custody? I'd see them maybe once every 2 to 3 weeks. And were they overnights? No, they weren't overnights. Well, why not? Well, my wife wouldn't let me have them. Okay. So then the next person comes up to testify. It happens to be the kid's teacher. How are they doing in school? They're doing great. How are their grades? In fact, their grades have increased since the time that mom and dad separated. Any behavioral problems? No, no behavioral problems. So you see where this testimony and this evidence is going. A judge is now seeing perhaps kids doing better under a scenario in which you're getting less time. Now, that's not necessarily an appropriate amount of time, but judges are not risk takers. They try to settle for a status quo. They don't want to rock the boat. They don't necessarily want to change things up. So with that kind of testimony, you're assuring that you're going to get less time than you really ever wanted or deserved. And so when you have kids, you certainly want to stay in the home because you'll see them all the time. There is something called parental alienation syndrome. And at night, I'll ask guys to raise their hand, and maybe one person in a room of 100 has heard of parental alienation. So I would encourage you to Google it. It is something that I think you can find in probably 9 times out of 10 in divorce cases. And especially when you move out, parental alienation tends to rear its ugly head. And it is something like, you showed up on Friday to come see the kids. She said, no, it's not a good time. And so then she shuts the door and the kids say, well, where's dad? And she said, well, your dad has a new family now, and he's left us for that new family. And he has a new girlfriend, and his girlfriend has, or his girlfriend has children, and that's his new family. But I'll always be there for you, and don't you worry. Or it's a birthday. Is dad going to drop my birthday gift off? Which you did, but she's destroyed, thrown away, given away, whatever. And she tells your child that, he's spending money on his new family, but I'll always be there for you. You can imagine the consequences of that type of behavior and those statements that mom makes towards the kids. That is parental alienation. It's destructive, and it is crazy when you see the results of something like that. And it is breeded by the fact that you've moved out. And so by staying, you can tend to try to negate some of those aspects and set those aside. So I'd encourage you to research a little bit about parental alienation. There are experts out there that can assist you in your case, that can testify, and judges and courts are beginning to accept the testimony and recommendations from psychiatrists, psychologists in regards to parental alienation. Now, whether you have kids or not, moving out has another consequence financially, and that is what I call double household expenses. So when you choose to move out, most of the time, the recommendation from your spouse's attorney is going to be, don't pay any of the bills. So now you've moved out. You moved into a 1-bedroom apartment that has no furniture because you left everything behind, including the kids. And now your wife will not pay the mortgage or the utilities at all on the home. So you're left paying that for her to stay there with your kids, to give you no custody, and to have her boyfriend also stay in your home. That is a scary scenario, but it oftentimes is reality. So by staying in the same home, keep in mind that most guys that we meet with live paycheck to paycheck. They can barely afford to live with one home with the income that they have. Yet you've now made the decision to move out to increase your expenses, and your wife won't pay the bills even though she makes money. And so you now are building a bad credit and things are going into default. So if you choose to move out after a consultation with your attorney, or it's not too late to move back in, that's a question that I would certainly pose to your attorney. We deal with it at Cordell Cordell, and we develop a strategy for you to perhaps get back in. But you can avoid the double household expenses by making good decisions early on. A lot about what we talk about today is about preparation. It's about strategy. It's about being prepared and ready for perhaps that's what the storm is, and that is your divorce. Now, you may already be in the middle of it. And a lot of these mistakes, guys, in the seminar we have say, gosh, I wish I had been here before I started. Well, it's not too late. That's the good thing. So we want to feed you this type of information to spur a conversation with your attorney. And the last thing on moving out is not necessarily anything about the law. It's about if you want to keep your house. Many guys have either built the home, improved the home, blood, sweat, and tears in the home. Maybe it was theirs before the marriage. It's now, not to get complicated with whether or not it's marital property or not, but they move out. Yet they come back to court and they say, well, Judge, I want the house. And the judge is like, well, you've left your wife and your kids there. I'm not going to move them out. So we talk a lot about, if you want the home, stay in the home. I mean, you want to gain advantage, try to get her out. because that, is really the ultimate. If you can let her move, you keep the kids and you stay, you're in a much better position. Oftentimes at night, I'll refer to this as driving the bus. You want to be the driver, not the passenger. Where the bus is careening out of control, you're steering the wheel or you're in the passenger seat. Moving out, you're going to be in the back of the bus in the passenger, and you're going to be all over that bus when it's careening out of control. So that's really about moving out. We'll keep moving on here. The next one really is allowing confrontations to occur, and that is orders of protection. It is, to me, probably one of the more abused provisions in the law, no matter where you are around in the country. The reason I say so is if you're not familiar with orders of protection, it tends to go like this. You get into an argument. It's not physical. It's about finances. It's about the impending divorce. It's about division of property. It's a custody schedule. And yet, now she sees an opportunity. She calls the police and says, he threatened me. You didn't threaten her. You guys may have been vocal. You may have raised your voice, but you didn't say anything. But she's going to say, yeah, he said he was going to hurt me. He was going to take my kids and kidnap them. You will never see them again. See, she can make those allegations and get perhaps what's called an ex parte order of protection, which is something that happens without notice, and there's a knock on the door and it's the sheriff that says you have 5 minutes to gather what you can in your hands. That's it, and you're out of the house, probably for the duration of the case. That's the problem with orders of protection. Again, judges are not risk takers. They want to maintain the status quo, because no judge wants to be on the news where something really happens, where they refuse to kick someone out, and then domestic violence occurs and someone gets hurt, injured, and killed, if, God forbid. So the point is, avoid conversations that involve arguments about it. Because I always say, you have to look at it from this perspective. When you got married, you were on one side of the table. You were next to your spouse, together, unified. You're looking out at your friends and your family. Now that you've got a divorce pending, she's on the other side of the table. It's no longer a unified front. It's no longer having the same goals, the same things in common, the things that you want to accomplish. It is now something where she's on the other side of the table. So you're not going to win a conversation. You're not going to win an argument. And even if you did, you would get nothing other than the satisfaction of winning an argument. That's it. So the pitfalls of abuse are that, because it impacts, again, expenses, because now you're out of the house. Court's going to perhaps order you to pay all the expenses for the home, which you can't afford. Perhaps it affects and limits your amount of custody and visitation with your child or children. Again, it can be used against you, perhaps, in certain jurisdictions. A finding of domestic violence can be used against you in an ultimate trial. And then there's always the complication of the ability to own or possess a firearm, especially when you have a finding of domestic violence. Each state, each jurisdiction has particular rules as it relates to firearms and your ability to carry or possess. I can't tell you the number of guys I meet with who are avid hunters. And they walked in, we didn't represent them. They've got a finding, an order. They tried it, and it was a finding of domestic violence, and now they've lost their ability to own and possess even a hunting rifle. So you don't want to get caught in that situation. It's just problematic. There's nothing good that comes about with allowing confrontations to occur, because they'll use it against you at trial. All right, let's talk a little bit about what we call is waiting for your wife to file, or I often refer to as whether or not I should file first. I'm a big proponent of strategizing and filing first, but I caution when I talk about this, and that is the unusual thing you'll hear from a divorce lawyer is that try to save your marriage. I oftentimes, people come in and have a consultation with me, and I ask them flat out, do you really believe that your marriage is irretrievably broken? You cannot save it no matter what you do. And there are times 50-50. Guys will hesitate, and I know that there's an opening. And I say, look, you're better off trying to go save. Don't retain me today. I want you to go try your best. Save your marriage. And the reason I talk about this is because it does dovetail into filing first. But save your marriage, because a bad marriage oftentimes is better than a terrible divorce, because there are no winners in divorce. It's degrees of losing, because you're going to walk out with less than what you started. You're not going to get 100% of anything. So everyone loses. But I talk about that because when the guys have done that, they've come back to me and they said, look, we did, I tried it, I gave it my best shot. I now truly believe in my heart that my marriage is over. Again, it's unusual to have that, but that's just kind of my firm belief, my foundation. I want to make sure that guys are ready and prepared to go the distance in divorce and that they've made a right decision because it's a significant one, not only psychologically, physically, because of the ramifications it has against your physical state, but also as it relates to financially, because it's not cheap. Now, when a guy says, yes, I'm ready, I've done everything I can, I always say, look, there's no reason to wait. Let's file first. And it's strategic, and it has nothing to do with the law. And that is, I like to present my evidence first. If I have to try the case, and whether I have good facts, bad facts, a combination, the worst thing that can happen for a guy is for your spouse, if you have to try your case, to start talking about everything bad about you. Like the worst things, the worst decisions you've ever made over the course of your entire life before you even get a chance to rebut it. It could be days while she's up on the stand talking to the judge about how bad of a husband you are, or how bad of a father you are, or all the things that you did wrong. My point is, I want to get those out because judges are derailed by emotion and they have an attention span that's limited. So imagine she's on the stand for days, hours, for the entire day talking about you and all of your problems and you and all the reasons why you are the reason the marriage failed. Like, it's not about pointing fingers. It's about if you get to file first, then you can set the stage. You can set the tone, especially if we do have bad facts, whether it's abuse of alcohol, gambling, financial mismanagement, extramarital relationships, whatever it is. Those don't bother me. They don't necessarily tank your case. The point is it provides an opportunity, and that is we have to present those facts first. Get them out of the way before an attorney can cross-examine you and try to intimidate you or to make it look like you are the bad guy. I can tell you that I opened our Georgia office and I was trying a case, and we filed first because I convinced the client. We had some shaky facts. Got them on the stand, got them all out first, took the wind out of the sails of opposing counsel. They didn't think we were going to bring it up. We did, and so we went ahead and did that. And the judge afterwards said, I wasn't bothered at all by the bad facts. You got them out, and we took care of it. And so that's the point. Representing guys is about appearance and presentation. How do you appear before the judge? Dress, demeanor, and what are you presenting? And so when you file first, you have those opportunities to set the stage. It is oftentimes, as an attorney, it's about telling a story and making sure you have a theme. And I'll talk a little bit about themes because I have some themes as it relates to mistakes guys make. So we're going to talk a little bit about that. So we want to get that out of the way. The other things to consider about filing first are not just strategically about you presenting evidence. During the kind of the latest recession in the early 2000s, I was interviewed by the Wall Street Journal. And they said, your guys can't afford to file. And I said, no, they can't afford not to file. Now, it wasn't a question about the ability to finance your divorce. The question was, and the statement was, that at your lowest level of income, at your lowest point in your employment, you would want to file now rather than wait till you're making the most. Because judges were accepting guys who made less. Their bonuses were cut. They had no more overtime. Their wages were decreased, whatever it was. So that's the point. It may be your decision to file may be dictated by a number of things. It could be your income. It could be your debt. She's spending uncontrollably. We want to get that taken care of and file first. And what I call put the debt Band-Aid on. I mean, say, look, Judge, we filed because she wouldn't stop spending. Our credit card debt is maxed out. And so I had no choice but to establish the line in the sand. It may be bonus and stock options. It may be promotions. 18 months from now, you may be getting a big bonus. You may be, or you haven't qualified yet for it. But looking forward, what are those facts and evidence that will dictate that we should file now? You may have a spouse who's unemployed for medical reasons. Her medical condition may be getting worse. there's no advantage to waiting. I don't want to be in the business of promoting divorce, but I want to be in the business of encouraging the right timing for filing for divorce. So I think it's important. It's one of the things that I think lawyers often overlook, and that is the strategic reasons to file for divorce. All right, let's talk about something in my seminars. I've oftentimes titled this long title called, Concealing Relevant Information from Your Attorney, or Concealing Assets. So basically, we'll just call this the theme. Remember, we were just talking about themes, and I like to refer to it as doctor versus lawyer. So I have a couple friends who are doctors, and I've had this conversation with them about their relationship with their clients. And I was trying to compare that relationship of doctor-patient, lawyer-client. And it was interesting. I said, do your patients ever lie to you? Have they ever given you facts that really aren't necessarily true in an attempt to get you to heal them? And they looked at me funny, and I said, that's what I thought. And I think we would all agree. And why I call this doctor versus lawyer, I'll give you the example. Let's say your right leg is bothering you. And so you call the doctor's office, and I'd like to make an appointment. And they say, well, why are you coming in? Well, it's my right leg. Okay, we'll see you tomorrow at 9 a.m. You show up at 9, you go back, and you're shuttled into one of the patient rooms, and a triage nurse comes in and says, okay, why are you here today? They always ask you to confirm. Would you ever think that you would say, well, I made the appointment for my right leg, but it's really not my right leg, it's my left leg? Knowing truthfully that it is not your left leg, but you're lying for some reason that you're not disclosing. No one in their right mind would ever suggest that to their doctor and lie about a condition if they truly wanted to be healed of the condition that they first reported, right? Now, the reason why I talk about that is the relationship that I just described that never happens with doctors and their patients often happens with lawyers and their clients. I'll give you an example. I had a client I met with in a consultation, and he was inheriting a lot of money and property from his father. We were able to give him some advice on how to keep it separate so that the court would not divide it as marital property. And, he seemed to be kind of a little skeptical of my advice, and it's very rare to be able to definitively state something in family law and tell a client, look, I am certain that we can do X for you. That is a rarity because there are so many variables in family law. Well, this was one of those opportunities where I said to the client, I'm certain that if you do take my advice, steps A, B, and C, you will get D, which is keep all of your separate property that you inherited. He didn't retain at that moment. Maybe a couple months later, he came back to retain, and I did not connect the dots about that conversation. We're in the middle of the case. We're doing depositions. We're discussing settlement with opposing counsel. And we settle the case. What I thought were good terms. I looked to the client and I said, hey, only thing they need is an accounting of your bank account. And I had told the opposing counsel absolutely, didn't hesitate because he had moved out. He was paying double household expenses. He had left kind of the kids behind kind of thing. And so all this money was coming in and out. He was also paying her maintenance or alimony, spousal support. And so I was really confident in our ability to do an accounting of his bank statement for just 60 days. Well, what I didn't know is that the opposing counsel knew, is I told my client this, and he basically admitted that he had lied to me about this source of income that was coming in. What was happening is, then I realized this is the same person who I had a consultation with. He was taking separate property income, depositing it into a marital account, writing a check to his brother every month that his brother was going to keep all this money, so at the end of the divorce, his brother would write him this check back. He basically didn't give me the information that I needed in order to protect him. He didn't treat me like a doctor who wanted to cure him. He treated me like the lawyer. And clients tend to make decisions like that. They're emotional. Sometimes the information they withhold is embarrassing. We know that. But believe me, there are many things I've seen over the 27 years that I've been doing this, and I'm rarely surprised anymore. And I always say, there aren't a set of facts that I can't deal with to put you in a good position to try to accomplish your goals. I mean, it's a rarity. There are probably some that we all can imagine that are pretty significantly bad, but this was not one of them. So the result of this case, because he decided to lie to me about it when I questioned him early on about sources of revenue, was we lost an opportunity to settle his case. Opposing counsel knew it all along. They were setting him up. I call it the one chip theory. If you're old enough to remember, I think it was in the 70s, Lay's had a television commercial called You Can't Just Eat One Chip because they're so good. Well, I call the same thing in divorce of telling one lie like the Lay's chip. One lie becomes 2, becomes 4, becomes 8. You keep having to build lies upon lies to support the original one lie and to keep it going. And so the reason I put this mistake on here is to kind of implore our clients or even prospective clients or guys like you out there that have lawyers to treat your lawyer, one, when you're interviewing them, and two, when you've retained them, like they're your doctor. Because you're giving your lawyer everything that's most valuable to you. Your property, your income, your kids. Everything's at risk. Everything is at stake. And so you want to make sure that you trust your lawyer like you trust your doctor. I always talk about choosing a lawyer is much like choosing a doctor and you've got cancer. You want to choose someone who just does oncology because you want them to heal you. And my doctor friends would tell me that they're getting information that is so unrelated to what they're trying to heal. Like let's say it's an arm issue, and they say, well, I've got a little bit of a runny nose, and my left toe has a discoloration, and that's the kind of thing we always talk to our clients about how important the smallest and littlest of facts are that may be the turning point for your case. And so that's why we list this as one of the most important mistakes, and that is concealing information, because you lose credibility, you lose a chance at settlement, because good lawyers can find what I call bad people. And that is, as smart as the plan that you think you've made, it's probably the worst plan because you'll get caught on it and you'll get called out on it. All right, halfway through. This one is, the short version, doing a sloppy job on financial records, which in the evenings when we do this seminar, I call insufficient consideration of financial documents. And albeit all of these are extremely important, but to me, probably one of the most important topics and mistakes guys make because it affects everything in your case. And so I call this, as you know, we talked about themes. We talked about doctor versus lawyer. This one we're going to call the tax return. And so in the evening, I always have guys raise their hands. How many have filed their own taxes? And it's a pretty significant number. They don't hire a CPA. They may go ahead and do, TurboTax, whatever it may be. And so here's the description. In every state and in every city around the country, you're going to complete a document called income statement, income and expense. What do you earn? What do you spend? And then you're also going to complete a statement of property. Those are the two most important documents that you'll ever prepare, whether you're facing a divorce, a paternity, a modification, or even a contempt. Because this is what the judges get. They look at what are you earning after what you spend and what do you have left over. I always say, if you show that you've got money left over, let's just say it's $500 after you've paid all your bills on the income and expense, what do you think the judge is going to do with that money? You think they'll just say, oh, Mr. Jones, you worked so hard, I'm going to give you that $500 of excess money back to you. Well, keep in mind that that 500 probably isn't an accurate reflection of what you currently have because these forms don't list all the expenses. We talk a lot about at Cordell Cordell, we don't take the forms for face value. We add supplements, addendums, things that we know, life and or a day in the life of expenses that perhaps aren't reflected in these documents. So let me get back to the tax return, why that's important. So we all file taxes. I know I get nervous come April 15, April 16, whenever that day is. We all who do it spend a lot of time going through, whether if we're itemizing, we go through receipts, we go through statements, we make sure that our math is correct. We use this magical thing called a calculator. and double and triple and quadruple check our math. And the reason we do it, the reason we spend hours and hours and hours on our tax return is because for years they've been ingrained in us is to fear Big Brother, the government, the IRS. No one wants to be audited by the IRS, right? And so we double check our math. We spend an inordinate amount of time on a tax return. So then the second question I ask the audience, and I'm asking you, how many of you have been audited? I can tell you that it is unusual that I get a hand in the audience where someone has said they were audited. So let me take you from this step. So we've spent a lot of time on something where the chances of getting audited are pretty slim. Go to our income and expense statement. Most guys that I meet with, they come to me, I'm the second lawyer in, which is okay. Believe me, judges don't care. They know that clients change lawyers midstream quite often. I say, well, how much time did you spend with your attorney on this income and expense statement? And they're like, well, I didn't. Well, what do you mean you didn't? Well, no, I put this together in 20 minutes and I gave it to my lawyer and I figured he would take care of it. So the point is you're spending 20 minutes on probably the single most important document in your case. Compare that to the tax return where you spent hours. So the chances of being what I'll call audited in your divorce case, in your modification case, in your contempt case, in your paternity case, I would say 99%, right? You're going to get cross-examined on the documents. You're going to get cross-examined on the statements, on the numbers, how'd you calculate them, where'd you get them. Yet, we've been trained to distrust our tax return. So the logic is broken here. I'm not saying you spend less time on your tax return. What I am saying is you need to spend an equivalent amount or more on what I know. If we're going to play the odds, you're going to get cross-examined on your financial statement. I'll give you an example. I was trying a case again in Georgia, and I like to take the opposing party's financial statements and I blow them up on very, very large boards so that, one, the judge can see the numbers, but two, it's a little intimidating when the document that they prepared that they probably aren't so familiar with because they only spent 10 minutes on is in front of them. I get a nice marker and I start Xing out and challenging them. And I challenged the wife on these numbers. And I can tell you that when I was done after about 3.5 hours, the 3 pages of her financial statement, there wasn't a single number left unchecked, meaning that every one of them I challenged her and she agreed with me was incorrect. None of them. Not only that, the math. She obviously didn't use a calculator because the math didn't add up. It was $6,000 or $7,000 too high. And so I destroyed her credibility. Afterwards, I rest my case. I see the judge lean back in his chair. He picks up a newspaper and starts reading the newspaper. And I looked at my client and I said, we just won. Opposing counsel's getting up. He's nervous. He's just started his case. He didn't file first. We did. Keep in mind what we talked about earlier. And he says, Your Honor, I just want to make sure you can hear my client because she's very meek. He's, trying to play this up. And he kind of peered over this newspaper and he said, don't worry, Alan, I've already heard enough. That was it. We won. At the end of the case, the judge said, boy, you took him to school and that's all I needed to hear. So the point is, we paid enough attention to the most important document that she didn't. Our client was prepared. She was not. Again, judges are derailed by emotion. He began to think that she was not credible on a couple items, so it affected everything. So the details, it's in the details, right? Avoid the common mistakes. List every expense. Talk to your lawyer about adding addendums. So what we do, use a calculator, pull out your bank statements, pull out your credit card statements. Make sure it does accurately reflect a day in the life. If you've got money left over on your financial statement, and you don't have money every month, something's wrong. You're missing an expense. So, the tax return. Compare the likelihood of audit versus certainty of review. This is the single most the most important document you will file. I encourage you to have that conversation with your attorney. If you don't have one, I encourage you to come into us. We'll take care of it for you. All right, let's go on to number 6. And that is neglecting the kids. And I'm a little bit concerned when I use this type of topic, neglecting the kids, but it's misleading. what it should say, and I do it for shock value, it should say stay involved. And that is from the day that you file for your divorce, exercise as much time as possible as you can with your kids. I even say, okay, let me put it this way, be the babysitter, be the nanny. Encourage your spouse. If you've moved out, call your spouse, say, hey, why don't you go out? You need it this weekend. I'll take care of the kids. I'll keep them all weekend. You need time away. And that is, it's okay. I know it's an inconvenience. It does inconvenience you because you then begin to feel that you're taking on all of the burden, perhaps in the decision making, in the rearing. But you want to keep a calendar. You want to keep a diary of all the times that you've done it because, again, judges aren't risk takers. The more time that you exercise, the more time that you can then show, yeah, I kept a contemporaneous calendar and notes and a diary. And exactly what we did. We got up, I made breakfast, I did, the laundry, we went and did this, we did homework. And you continue to do this and you show that you're involved as much as you can. It's going to lend credibility. Again, the more time you have, the more than likely the judge is going to stay with what you're exercising. Know your kids' teachers. Get involved. Parent-teacher conferences, doctor's appointments. I bet you didn't know that when you go to the doctor, the nurse is writing down mother presents with child, or father presents with child, or or both. So you can subpoena those records to show that you've done exactly what you've gone to every doctor appointment, or maybe your wife didn't. Dentist appointments, same thing. Be involved. Know your, again, the teachers, the parent-teacher conferences, email the teachers to be involved. Hey, how is, Johnny doing? Any concerns that you have that I can work on with him? We're going through a rough time. And then you can call the teacher. Did Mr. Johnson reach out to you? He did frequently. Did he seem concerned and involved in the child's life? Absolutely. You see where I'm going with this about staying involved. It's important. Shopping. Know your kids' clothing size. Know what they need. Know who their friends are. Know who's around in the neighborhood. Go to sporting events, extracurricular activities. The things that maybe you didn't have time for because you were the breadwinner and you had to work. These are the things that, yes, over the course of the next perhaps 12 to 18 months, you're going to have to change some of the things that you do. Change your schedule to maintain being involved. Cook. Learn how to cook. Go to cooking class with your kids. Do things that are unique, not just regular and routine. The lunches, the laundry, the homework again. Again, keep everything in a diary. You want to make sure that you're recording a day in the life. It makes your lawyer's job much easier. You can present all that evidence at trial if you need to go to trial. And again, it's what we always refer to as contemporaneous, which means you didn't wait 6 months to compile the data. You did it at or near the time of the event. So we always tell clients, look, every night, just start writing in the calendar. What did you do today? And I mean the littlest of things. Again, keep in mind, I want the little details. But that is one of the mistakes guys make, is staying in the rut in which they were used to doing because maybe there was an agreement. Your spouse stayed home. You worked. She did most of the things at home. Well, things are different. So you need to make sure you don't neglect the kids. Again, caution with that, and that is just stay involved with the kids. All right, number 7, talking too much. Again, word of caution on this one, and that is I don't encourage clients to not speak with their spouse. What I talk about is, again, this is another themed opportunity. We talked about doctor versus lawyer. We talked about the tax return. And so in this one, this is, we've all heard of Texas Hold'em and poker, right? And so imagine this, and I say silence is golden here. And the opportunity we want you to do is, you don't want to speak with your spouse about the things that are most important in your case, trial strategy. You spend a lot of money, for me, or your lawyer, to develop a strategy to put you in the best position possible to kind of achieve the goals that you have. Something we haven't talked about yet is goal setting. One of the first things you need to do with your attorney is set some goals, right? So let me just get back to this. That is poker. You've set your goals, you've talked about your strategy, you've implemented that strategy, you've spent a lot of time and money, and so now let's talk about poker, Texas Hold'em. So imagine in Texas Hold'em, you've got your 2 down cards. There's no more bets at all in the center other than your small and your big blind. You look at your cards, and you've got two aces. Who in their right mind would flop those aces over before anyone's bet, additionally, and say, who's in? Everyone would be out if you flopped your aces. Much like divorce. If you share your strategy, why would they continue or why would they stay on the same path? Example. About 25 years ago, I had a client. We were trying to position him to get the custody that he wanted. And during the interim, he was getting equal time. So he had moved out, but we had, he was being the nanny and the babysitter. And keep in mind, all these things kind of have been created over time from cases that I've observed. And so he was doing everything we wanted him to do. And by the time we got to trial, we were just on the cusp. We had hired an expert, a psychologist who was going to testify that she had observed dad and the kids, interviewed dad, but did not interview mom. So she couldn't make a recommendation, but she could say something based upon her observations. And that was, they had a great relationship. And the amount of time that they were spending, the equal time, anything less or deviating from that would be problematic and probably cause harm to the kids. And so what happened to him is going to happen to you. And that is, your wife, his wife, started coming at him one night, talking about how I'm going to take all your money, I'm going to get all the child support, I'm going to get your house, your 401k, your pension, I'm going to get everything. I'm going to keep all the contents in the home, and guess what? Your lawyer's terrible, and you're going to pay my lawyer, and so I'm going to actually wind up with 100%, you're going to get nothing. About an hour into this, she's just going after him, and he breaks. And he says, oh yeah, well wait till you hear from my expert. She stopped. She got exactly what she wanted, which was she wanted to see his cards. He showed them. He showed his aces. So what did she do? They did not know we had an expert. We're about 2 weeks out from trial. They went and got an expert. Experts offset. We wound up losing because he didn't see that silence was golden, right? He didn't respect the poker game. And that is, it is, unfortunately, not to denigrate your relationship to either a business transaction or a game of poker, but it's strategy. So there are many things better left unsaid, and certainly do not show your aces. And he did. He was baited into doing it. He was almost baited into an order of protection because they started getting angry and yelling about positions and about who was going to win. And again, the point is, he would have been better off walking away, keeping his aces in close to the vest, waiting till people put all in, waiting till more bets were in the pot, and then, of course, showing. So what I do want to encourage guys, though, and that is, do encourage talking to your wife when it relates to kids, when it relates to legal custody, major health, education, and welfare decisions. You should continue to talk. Continue to talk about resolution, but don't share your strategy. Just listen. See what happens. Maybe you'll get a piece of information that she shows her aces. So again, talking too much can be damaging to your case. Mistake number 8 is really revealing too much on the internet. This is one that's really come up, I would say, over the last 10 years or so. And so I ask every client when they come in the door, tell me one social media post that has actually assisted your case in accomplishing one of your goals. And I'll sit there and I'll wait. And there's silence because there isn't one. There has never been an opportunity, there's never been a moment where one of my clients has posted something on social media that actually advanced their case. It hurts your case. And I know everybody lives on social media. They got to post on Insta, and they got to check out Facebook, or I got to tweet today. I haven't tweeted in a while. The point is, it is detrimental to your case. I was on Dr. Phil, it was a while ago, 10, 15 years ago, maybe a little bit more. I was the expert of the day when I talked a lot about the use of social media when it was just coming on the scene. And so what they did, and they showed me photos that I was not prepared for, because I said, just go ahead and do something and I'll testify, I'll talk about it. So they said, okay, Scott and Dr. Phil, here's some photos on social media. Tell me what you see here. So what I was shown were what otherwise would probably be innocent photos of mom. She was talking with her friends. In the background were bottles of vodka and gin, and then her child was in the background. And so they were probably just bottles that were probably on a tray that are, decorative, right? So I turned it into, well, it's obvious. Mom's drinking in the presence of her children, overindulging. She's an alcoholic, letting her children be exposed to people that they shouldn't be. So you can take anything. You can take and twist any photo on social media to use to your advantage. And so my point is, what I tell clients is, the first thing I do before I meet with every client is I check it out. Do they have a social media account? I look them, I search them, and see what's on there. So I get a kind of an understanding of what they're doing and how active they are. So a couple things. Don't delete your account, just deactivate it. Tell your friends to stop tagging you and posting about you, photos, whatever that can hurt your case. You need to just stop. Wait till this is all over. Because I've had clients ignore my plea to stop using social media. We're in day 1 of a 4-day trial, and they post something negative about a ruling the judge did. Guess who's looking at social media? The judge. And the judge saw a post about them. Now the case is over because judges are derailed by emotion. Now they don't like my client. It doesn't matter about the law. They have all this power. Winning on appeal is very difficult. So I always suggest get off social media. There's no good that can happen, but encourage your wife. Oh yeah, keep posting. Yeah, how's it going? And we look at her social media account. We use it. You'd be amazed what you find. No one's filed for divorce yet. She's listing as single, interested in men. Still married, but I'm posted as single. We use all that against her, right? So we want to encourage, you can be friends with her and her friends. We want to do that and continue to use that information against them. Social media is very powerful in divorce. We want to be able to use it, not have it used against us. So again, deactivate. I know, resist the temptation. You'll be better for it to have a hiatus from social media. Mistake number 9, failing to fully engage in your case. This is very similar to neglecting the children, that mistake that we talk a little bit about. But it's the difference being is we just don't focus. And the mistakes guys make is, oh, my lawyer's got it. I don't need to do anything. What we want our clients to do, and we encourage you to do, is to be involved in the preparation of your case. Be involved in the gathering of evidence. Be involved in the collection of anything, whether it be retirement statements, bank statements, credit card statements, deeds, tax returns, W-2s, 1099s, K-1s, everything. Because the more that you can do, the less money you're going to spend. Again, divorce is not cheap, and we encourage our clients to help us to prepare for their case. If you want to prepare a spreadsheet of all of your spend in the credit card statement, or instead of us hiring a forensic accountant to go through your bank statement to show money in, money out, you can help do that and at least get us started in the right path. We encourage our clients to start gathering that. Again, if you're thinking about moving out, it's a great opportunity to become fully engaged in your case, and that is start gathering the documents that are critical and crucial. Because if you leave without them, they may or may not be required to produce them voluntarily. So that means I have to spend money. I have to prepare either a subpoena or a request for production of documents and spend $500, $600, $700, $800 asking for them. Another equivalent amount of money when I get them, preparing them, looking through them, preparing a spreadsheet. Again, this runs and adds up very, very quickly. The other thing is to be involved, and this is key, with your attorneys. When you go meet with them tomorrow, today, next week, insist on monthly updates in writing from your attorney. Be engaged. You want to know what's going on in your case. For example, for us, we have a process in which we automatically update you in writing on a monthly basis. We have a portal, a client portal, where you can see at any given time all of the notes that the attorneys are entering on your case about what's happened today, what's going on tomorrow, what's coming up next week. Being engaged, know what's happening, be familiar, because you may see something in the notes and say, hey, I saw this, I can help you with that, or I got more information about this. So you want to stay engaged so that you can help drive that bus, right? You want to oftentimes stay engaged with your spouse. We talked about talking too much, but what's important is also listening. Listening to what she's saying, because you may pick up on some strategy. You may pick up on a weakness that relates to something that's an opportunity for you to negotiate in a settlement. Staying engaged. It's oftentimes difficult to stay engaged because it's a very emotional, very trying point in your life. It's taxing emotionally and physically. We encourage clients to get counseling during personal counseling to make sure that they stay engaged, that they understand what's going on, that they're not overwhelmed with emotions because it's really easy to get caught up. And then lastly, one of the things we do at Cordell is we give what's called a significant issues letter. And that is, we want to let you know what the law, the most relevant, most current, most applicable law is in your case. And so demand that. And I want you to read it. We'll give you the case law that regarding spousal support. We give you the case law regarding property division, about custody. So you know what we're talking about when we start making recommendations of what we think is most likely to happen, the best case and the worst case scenario. So insist on updates on the law, insist on seeing everything and making sure you understand. All right, getting close to the end, we've got mistake number 10. And that is, again, kind of dovetailing into staying involved, and that is being ill-prepared for testimony and interviews. So one of the things that I think family law is plagued with, and that is attorneys who perhaps don't like to litigate, and they want to settle or mediate at all costs. We are a domestic litigation firm, and what that means is, foundationally, we truly believe that the best way to resolve your case or to get yourself in a position to resolve your case is to be prepared to go to trial. I mean, like any negotiation, no one will negotiate unless they fear that they have something to lose. So if you, like in a contract or you're buying a car, if I go in and do nothing and say nothing in response to what they offer, and they think I desperately need the car, then they're going to stay at their highest number, and because they know I'll never walk away. But if I take the position that, look, I don't need your car, I can go down and see 10 other dealers, then they may negotiate. Similarly in divorce, if they fear that we have something, that we were to try the case, that their result may be worse than what they are offering, of course their offer is going to be different. So what we fundamentally believe, and that is we prepare for trial from day one. We make sure that you're prepared as well because we think it produces better opportunities. It doesn't mean we try every single case. What it means is that the opposing counsel knows when they have us on the other side that we're going to be ready to go, that we will have reviewed all the evidence, that we will put you in a position to get you qualified for a really good discussion about settlement. So with that means that you should be prepared. And so when I talked about family law being plagued by that, that is when you have a lawyer who doesn't like to try cases, hasn't tried a lot. You know, there are lawyers out there in family law that say, yeah, I settle everything I have because I'm really good at negotiation. Well, what that really means is I am good at settling cases because I really don't want to try your case because I don't like going to trial. That means you're probably not getting the best result. I would say 50-50. Some are probably really good, but some probably could have been far better had you prepared from day one. And so they won't prepare you for your testimonial hearings because they don't want to have them. They won't prepare you for the interview with a guardian ad litem because they don't want one, because they think they can negotiate for you before we get anywhere near that. So what you need to know, especially when we represent guys in divorce, that is you have one opportunity. Your first mistake is your last mistake, because judges will look at you with a lack of credibility once you make a mistake, whether it be, remember we talked about financial records, and that is the tax return, whether you make a mistake in the math, whether you're not familiar with how you calculated it, you're not familiar with the number you put for electricity or for food or recreation or clothing. I mean, I could go down the list. The point is when you, as a Cordell client, go to court, you will know it inside and out. You'll be in our offices 2 weeks in advance. You'll be prepared. That's the way it should be. And so what I'm saying is that tomorrow you should be talking to your attorney about, hey, you know what, I've got a hearing coming up. I want to come in and be prepared. Can we go through the questions? Can you cross-examine me like you're the opposing counsel? I want to be comfortable with it. Because you get one shot. If you're going for a temporary hearing or a motion on spousal support, you want to be prepared for that. Again, about representing guys is about appearance and presentation, especially if you have bad facts. So we want to walk you through about talking about the bad facts. It says, yeah, I had an extramarital affair. I did. And my marriage was broken before that. And am I wrong for doing it? Absolutely. Acknowledging fault. We want to kind of coach you through that. We want to kind of get you prepared for those opportunities where you're going to talk about it. Again, being prepared. Depositions. If you don't know what a deposition is, there may be an occasion, it may be rare in Nevada, for you to be deposed under oath where opposing party can ask you questions about the case. You must be prepared for that. You have to be prepared for those opportunities to answer those questions, because once you do, you're going to be kind of put into a box about whatever it is. So why don't you want your wife to have 50-50 custody? You better be ready for that answer. Whatever it may be, why did you have this? Why did you spend that? For example, we talked a little bit about being involved in your kids' lives, not neglecting them. What size shoe does your child wear? I've had guys really stumble on that. Now, is it important in the grand scheme of things? No. But it makes you nervous, and it makes you think you better settle, and it shouldn't. So being prepared. Again, you have one chance on the stand, and that should be the most important opportunity for you to present your case and know it like the back of your hand. When they try to cross-examine you and catch you on your financial statements, your tax return, remember, you know it. And the judge looks and goes, okay, he believes you. You have to establish credibility. All right. So if you've heard some of the information at all, there's some question and answer opportunity for you. If you want to ask something on the chat box, I'll try to get it. We have a couple of minutes left. If otherwise you'd rather just have an opportunity to come in and ask some questions of our lawyers in Nevada, there's some contact information on the screen, or you can actually reach out to us at CordellCordell.com or mensdivorce.com or dadsdivorce.com. Let's see. So if there are any other questions at all, I'll give you an opportunity to ask one real quickly before we sign off. All right. Well, we look forward to helping you. We'll do a couple more of these webinars. We think they're really good information. We'll do it on a different topic, perhaps on modifications and paternities, because we think those are always good opportunities to get more information to you. Again, contact information is on the screen. Please reach out if we can help you. Until next time, have a good day.